as the topic suggests, uh, there is a dynamic relationship between changing face of society, the law, and the medical profession. An evolution, so to speak. And in this talk, I'll be briefly taking you through the evolution of medical law principles, negligence principles, uh, through a few randomly selected recent judgments. So, in the ancient times, medical negligence was treated as a crime. Up to the 1800s, the patients had a commanding role because it was treated as a trade contract. And in the mid-90s, with the Hunter versus Hengley case, which said that there was no doctor was guilty if he had applied ordinary skill, if acting with ordinary care. And this was further confirmed in 1957 in the Bolam versus Friar Hospital Management Committee decision, which said that a doctor is not guilty if he acts in accordance with that accepted by a responsible body of medical men of the relevant specialty, even if others disagree. And the Bolam test remained the gospel for medical negligence law for almost 4 decades. And the medical profession, it was almost the golden period of the medical profession as far as medical negligence was concerned. However, in the late 1900s and early 2000s, with a rights-based society coming up, Bolam was criticized that it was too paternalistic, governed by the medical profession, that the profession had set their own legal standards for an ordinary level of practice, which would lead to a decline in medical standards, and that the medical fraternity accepted what was done and not what ought to be done. And of course, the courts had been relegated to a passive role as far as deciding on what the standard of care should be. At the same time, the judiciary was trying to establish how to be able to take over the judgments, how to decide the standard of care from the medical profession, and also how they had to just take over the profession. Now, the Bolam test got a blow in 1997 with the case of Bolitho versus City and Hackney. And one of the judges, though the doctors were not held liable, one of the judges stated that the court is not bound to let a defendant doctor escape liability for negligent treatment or diagnosis. And just because it is evidence from a number of respectable, reasonable, responsible medical experts. Instead, the court has to be satisfied the opinion relied upon has a logical basis. And this is what formed the Bolitho principle. It strengthened the court's ability to choose between expert medical witness testimony, between the bodies of competing medical bodies. And also, it enabled them to form their own opinion whether a responsible or a reasonable standard of care had been administered to the patient. Another blow was dealt to Bolam in the case of Sidway versus Royal Bethlehem Hospital in 1985. At that time, according to Bolam, risk of treatment depended on the judgment of the medical profession, of the doctors. And rare surgical risks were not explained to patients prior to surgical procedures. So in this, the judges commented that the rights of a patient were equivalent to human rights, and that the doctors had to explain risks of treatment and procedures considering what a reasonable patient or a reasonable person and that particular patient would attach significance to. For example, if he was told of the risks, he had the right not to go in for that particular procedure or treatment. And they came to be known as the reasonable patient test and the particular patient test. The third thing that really dealt a blow to Bolam was for the amount of consent that had to be taken, and the Sidway was confirmed by the Montgomery principle in Montgomery versus Lanarkshire Health Board in 2015, in which the judgment said that the doctor has a duty to take consent and inform the patient of any material risk inherent in proposed and alternate treatments, except when applying therapeutic privilege or in emergencies. And the material risk was defined. And this changed the law of informed consent from doctor-based to patient-based. By the early last decade, Bolam had been discarded by the United Kingdom, by Australia, and by for all purposes of consent or treatment, and by Malaysia for consent. America, of course, never believed in the principle of Bolam. They always believed in the rights of the patient. In India, medical negligence was considered a crime in ancient times, but since India followed English law, the Bolam was a standard for medical negligence cases, and the landmark case of Jacob Matthew in 2005 laid down that the Bolam test was the most efficient measure of testing medical negligence. And there are many cases, landmark cases, that have been decided on the Bolam test. The first reference to the Bolitho principle was made in 2001 in Vinita Ashok versus Lakshmi Hospital in 2001, and where they said that it can be demonstrated that the professional opinion is not capable of withstanding logical analysis, the court would be entitled to hold that the body of opinion is not reasonable or responsible. And then again in Samira Kohli versus Prabha Manchanda in 2008, though they said that we have, however, consciously preferred the real consent concept evolved in Bolam, a beginning has been made in Bolitho versus City about controversies on Bolam. And in Malay Kumar Ganguly versus Sukumar Mukherjee in the Supreme Court in 2009, the court took an extensive, the court looked at the medical literature extensively, examined expert witnesses extensively to make their own risk analysis and come to a decision. And they also stated that Bolam was weakened by the cases of Sidway versus Hackney and Roger versus Whittaker and the Australian and Canadian principles. In the Maharaja Agarsen Hospital versus Rishabh Sharma, December 2009 by the Supreme Court, the judgment declared that though the Bolam test has been discarded by courts in England, the test holds good in its applicability in India. They also took over the Montgomery dimension, that stating that the position in relation to risks of injury by treatment are those adopted in Sidway and Roger versus Whittaker cases. And they also took the Bolitho dimension, where the evidence of acceptable medical practice is a useful guide for the courts, and it is for the courts to educate on what is the appropriate standard of care. So they had gone into the Bolitho and Montgomery principles. In Gagandi versus Veerpal Kaur in January 2021, the State Commission also discarded the use of Bolam for consent. The same thing in Krishna Institute of Medical Sciences. The judges and they did extensive risk analysis and scrutiny of medical literature to come to a decision on whether the doctors are liable or not. However, Bolam was also used in the same period of time. In Krishna Rao versus Nikhil Super Speciality Hospital, the Supreme Court judged that the court had used the Bolam test in decision as it was a standard laid out by a larger bench in the Jacob Matthew versus State of Punjab case, though they commented that parameters set down in Bolam test on medical negligence should be reconsidered. They also used the Bolam test in Arun Kumar Manglik versus Chirayu Health and Medical Care Center, that is the Supreme Court, though they put a rider saying that the court has also stated that the law in India should take account advances in medical science and adopt a patient-centric approach. And there are a whole number of cases between the period of 2009 to 2022 in the Supreme Court, the High Court, the National Commission, the State Commission, who have used Bolam. Interestingly, the Haryana government published a notification in 2018 that the district medical boards should examine complaints of medical negligence in the light of orders passed by the Jacob Matthew case by applying Bolam's test. So coming to the question of is Bolam relevant post Bolitho and Montgomery, I like to answer this in two ways. One is Bolam relevant with Bolitho and Praise? So Lord Wilkinson in the Bolitho case, he said that the assessment of medical risks and benefits is a matter of clinical judgment, which a judge would not normally be able to make without expert evidence. And he went on to say that in particular cases, the judge, before accepting a body of opinion as being responsible, reasonable, or respectable, will need to be satisfied in forming their views. The experts have directed their minds to the question of comparative risk and benefits and have reached a defensible conclusion on the matter. So basically, the Bolitho principle relies on reasonable expert opinion which has been subjected to a risk analysis. And simply put, Bolitho is basically Bolam reined in check by subjecting evidence to risk analysis. And therefore, Bolam is relevant even in the presence of Bolitho. The second part of the question is, where does Bolam stand in India today? It is, for risk of procedure, Montgomery principle seems to have been accepted by the Indian courts. For diagnosis and treatment, we've seen that the Indian judges use both the Bolam principle as well as a risk analysis using the Bolitho approach, while retaining a deference for the Jacob Matthew judgment stating Bolam as a standard. So is this a Bolam-Bolitho test where the judges are trying to balance the rights of the profession and the patients, or is it just a gradual transition to the Bolitho test? That, ladies and gentlemen, the court has to decide. Thank you for your attention.
Thank you, Dr. Juneja, for simplifying this very complicated terms, Bolam and Bolitho test.